We're holding this meeting using video conference technology. The public session is accessible on Jacob's website to watch via live stream. To conduct this meeting smoothly, I'll do my best to recognize anyone who wishes to speak. It is important that only one person speak at a time. And in addition, I ask that when you do speak, please identify yourself so that we have a clear record. We still need to take votes by roll call to ensure that everyone is counted. As a reminder, please mute your phone when you're not planning on speaking. Let's move to item 2 on the agenda, approval of the minutes from the August public session behind attachment A. Any questions or comments?
I'll move it.
Second.
I want a team.
Thank you. You guys in Albany, you're going to be doing a lot of that today. So,
Mr. Chair, we aim to please.
thank you, sir. Appreciate it as always. Martin, can you take the roll, please?
Yes, on the minutes, Commissioner Cohen,
Yes.
Commissioner Deering,
Yes.
Commissioner Fisher,
Yes.
Commissioner Horowitz,
Recused. Or abstain. I wasn't here for that meeting.
Commissioner DePiero,
Yes.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Commissioner McCarthy,
Yes.
McNamara,
Yes.
Commissioner Weissman,
Yes.
Judge Yates,
Yes.
Chair Rosen.
Yes.
Motion passed.
Okay, item 3, report from staff, please.
Sure. This is Monica Sam. We'll start with the outreach update. At the last meeting, the Commission issued Advisory Opinion 20-01, which has been posted on our website and distributed to all agency ethics officers. It applied the principles in a prior Advisory Opinion 1801 concerning the lifetime bar to a long-term project and concluded, based on the specific circumstances, that the lifetime bar did not prohibit the former employee from working on a different aspect of a project. In addition, I just want to announce that Jacob is holding its annual CLE event with City Law and New York Law School. It's on Tuesday, October 13th. The topic is Ethics and Innovation in New York State, Navigating Conflicts when Government is a Partner. This year, we're only doing one panel. It will be virtual, but there still will be CLE credit. If you're interested, if any of the commissioners are interested in participating, coordinate with Walt. We're hoping for a lot of attendance. City Law said that they've had success with their virtual CLE programming, and we've had a lot of positive feedback in the past. Does anyone have any questions about the panel? We issued our spring summer newsletter a few weeks ago. Again, that's put on our website and it's distributed to ethics officers. And finally, in response to timely questions concerning whether state employees can volunteer in connection with the volunteer as poll workers in connection with the election, we issued an ethics reminder within the last few days about the topic and how to analyze the conflict. So that's really the outreach update. With respect to the 2021-22 budget, typically around this year, we get the call letter from DOB. We haven't received it yet. Last year came a little bit later than the September meeting. We expect it will probably come the next few weeks. Often the turnaround is tight. It's possible that we will have to respond with our budget request before the next meeting. So if any commissioners have questions, want to talk to us offline between meetings as we prepare our budget request, we can keep people informed just when we do receive the call letter and any guidance that we get from DOB as to what to expect for next year's financial planning.
Monica?
Yes.
When you get the call letter, would you be so kind to share it with everybody?
Sure, no problem.
Thank you.
Any other questions? Okay. The next item on the agenda, if we want to proceed, is a proposed advisory opinion. This is an advisory opinion that the commission has seen before. It's attached at tab B. We've been working on this advisory opinion with the commission for a long time now. It was last presented to the commission in February, which feels like a lifetime ago, to avoid creating any delays or confusion about donations and support during the health crisis. We delayed discussing this again until now. You may recall that we previously had made changes to address various concerns raised by commissioners, and at the February meeting, additional concerns were raised. Commissioner Yates, you particularly had asked us to address an issue, and subsequent to the meeting, we added a footnote and I think reached a consensus that the issue was resolved, but I don't want to speak for Commissioner Yates. But we added footnote 6 to the advisory opinion. So we're asking now that the commission vote to approve this advisory opinion. And if anyone has any questions about the substance, I will turn it over to Deputy Director for Ethics Guidance, Michael Sand, for any questions.
Any questions? All right, not hearing any or seeing any. Can I have a motion to approve, please?
I'll move.
Thank you. Second? Thank you. Martin, the roll, please.
On the advisory opinion, Commissioner Cohen,
Yes.
Commissioner Deering,
Yes.
Commissioner DePiero,
Yes.
Commissioner Fisher,
Yes.
Commissioner Horowitz,
Yes.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
Commissioner McNamara,
Yes.
Commissioner Weissman,
Yes.
Judge Yates,
Yes.
Chair Rosen.
Yes. Okay, attachment C, the proposed meeting schedule.
Sorry. Attached, again, at C is the proposed meeting schedule for January to June 2021. We usually try and prepare it a few months in advance. So if between meetings, you could all take a look at the proposed schedule. We've tried to avoid holidays, but if you have any conflicts, please let us know, and then we will try and finalize the schedule at the next meeting.
Okay, thanks. Unless anybody has anything further that is not on the agenda, that concludes the public session.
Mr. Chairman?
Commissioner Levine. Yes, go ahead.
Yes. I have several items, if I may have your indulgence.
Go ahead.
First, I'd like to have staff address the operation and implication of Executive Order 202.6, which, as I understand it, exempts not only from the Public Officers Law, but all statutory or regulatory protocols, volunteers or others who may be retained for pay by the state who are assisting the governor in responding to the public health crisis. And I have specific questions regarding this executive order. But my first question is, have I properly characterized its broad ambit?
Oh.
I can address that, Commissioner Levine. So you have, with one slight correction, I think your characterization is accurate. There was a clarification in Executive Order 202.7, which limited the application of the previous EO to those volunteering or hired for a nominal salary. So it was not intended, or excuse me, it appears from the clarification that it was not intended to cover those who were hired for these positions. What the executive order did was remove from the definition of a public officer or state employee from the public officers law those who were in these temporary positions to aid in the response to the COVID-19 pandemic. It also suspended certain aspects of the gift laws for lobbyists and public officials to allow the state to solicit from lobbyists gifts to aid in the COVID response and allow lobbyists to provide those gifts when they wouldn't otherwise have been able to. Because of the exclusion from the definition of a state employee of these individuals, by extension, they were also excluded from the requirement to file a financial disclosure statement. And then finally, application of post-employment restrictions would not apply to these individuals when they resume their private sector duties after volunteering for the state, so as they wouldn't be penalized for coming to volunteer in the COVID response and then turning around and then being restricted from carrying out their previous duties before the COVID response in their private sector capacity. So I think that generally covers it, but if you have specific questions, I'm happy to address those as well.
Yes, I do. The executive order addresses those who are volunteering. The executive order also has at least one provision that addresses those who are not considered state employees but are being paid by the state. And it specifically exempts them from subparagraph 1 of subdivision 1 of section 73. What is the implication of that exemption?
Well,
those who are being paid.
Well, as I mentioned earlier, and I just want to check it again, that limits that. Respectfully, I think your statement about those being paid is incorrect because, as I mentioned earlier, 202.7 appears to modify that to limit it to only those who are hired for a nominal or no salary in a volunteer capacity. So I don't believe, and again, this is not our order, this is something that was issued by the executive by the governor, but my reading of that is that it is not applicable to those who were hired, but rather those who volunteer. But don't want to speak to the intent of the government courts. So that's all I would say to that extent.
The order as extant provides that there is some protocol for identifying and recording recusals. Is that correct?
The order provides that the agency or entity bringing that person on board may decide to implement recusals on an individual basis with the person volunteering. As for protocols, I don't believe, and I'd have to check again, but I don't believe the order established any sort of protocols as to how to go about that. But again, this is outside of our purview. I'm just giving you my interpretation of how I read it.
Right. So far as staff knows, if I may continue, Mr. Chairman, so far as staff knows, is there actually a list of all the individuals that Executive Order 202.6 currently is applicable to who are involved with the state?
I'm not able to answer that. I can find out, but I don't have any information right now.
Well, so far as staff, may continue, Mr. Chairman, so far as staff knows, is anyone or any entity within the administration maintaining a catalog of who these people are, what their affiliations are, whether they would, by their circumstance, be deemed a so-called interested source under our regulations, whether they're doing business with the state, whether they're lobbyists, and the list of these so-called recusals that have been provided for in the order. Is any of this information available so far as staff is aware?
I don't have any of that information. As you know, the executive order removes these people from our jurisdiction, so by necessity, we would not by necessity, not know.
Right, but again, on the follow-up, Mr. Chairman, can the executive order be interpreted as exempting all of those who are lobbying the state, doing business with the state, or engaging in political fundraising from having to file anything with anybody that is open to public disclosure? Is that a fair interpretation of the order?
Commissioner, I mean, as Martin has tried to caution, this is not our executive order. If you want us to direct your questions to the chamber about how they are interpreting and applying their executive order and what records they are keeping with respect to people who are covered by their executive order, we can do so. But we are not in a position to continue to interpret the chamber's executive order and what its effectiveness is. If a question or a specific situation arose, then we would consult with them. But if you want us to get answers to questions on how they are interpreting their executive order, we could do that. You could give us a list of questions, offline, however you want to communicate them to us, and we will pursue them.
Mr. Chairman, if I may express myself.
Go ahead.
You are very indulgent in allowing me to express myself. First and foremost, I feel very strongly that the governor should have anyone involved that he wants involved in addressing the crisis. There is a model that I believe is pertinent to deal with conflicts, and that is the one presented by the Business Corporation Law, where the conflicts are fully disclosed. The conflicts may be waived if it's in the interest of the corporation. Similarly, I repeat parenthesis, the governor ought to have whomever he wishes to have involved in responding, and the conflicts legitimately can be waived. However, I believe there is a matter of accountability and disclosure. So far as I can ascertain, the list of people who are the beneficiaries of this executive order have not been listed for public disclosure. If they are listed for public disclosure, I will stand corrected. But I believe that the staff should be directed to immediately consult with the executive chamber to ascertain the list of people to whom this order currently applies, whether their circumstances are such that they would otherwise be interested persons or lobbyists or doing business with the state, and also that the recusals that have been identified ought to be publicly disclosed. Does it require a motion to have the commission direct the staff to have that consultation with the executive chamber? Can you hear me, Mr. Chairman?
I heard you, Gary. What is it that you're asking?
I'm asking that the staff be directed to have an immediate consultation with the executive chamber and report back to us with respect to, one, is there a list of individuals to whom this executive order applies? What are their particular circumstances with respect to being an interested party, which is to say, are they lobbying professionally or otherwise doing business with the state? And thirdly, what recusals have already been identified administratively?
Okay, Monica, do you have any issue with that? Martin?
We don't need a motion if that's what the commission wants us to do. Much of this information is not, I don't know whether or not the chamber has made it publicly available. It's not required to be publicly available, and it will be up to the chamber. We could talk to them if that's what the commission wants us to do.
Well, in fairness to everyone involved, including the executive chamber, we ought to make the inquiry. If it's available, that resolves the matter. If it's not available, then there ought to be a further discussion amongst the commission in public session at the October meeting.
Yeah.
It looks like the Commissioner Fisher wants to speak.
So I'd like to suggest maybe a variation on what Commissioner Levine has asked. I think as a practical matter, it would be useful to know who staff should not be seeking disclosures from. Like by default, we get a list of who's subject to our jurisdiction and who's filed and who hasn't. So unless someone tells us not to go after someone for exposure, staff's gonna go after them, right? Or I don't know, go after, maybe that's the wrong term. But, as a practical matter, it would be useful to know, don't expect any of the normal disclosures from this person because due to this executive order, they're not required to file with JCOPE. Therefore, our staff shouldn't waste any time chasing down disclosures that aren't coming. So, why wouldn't we just say, can we get a list so we don't waste our time?
I just have a comment on that, a question for Monica. I mean, Monica, you had mentioned that should an issue arise, part of the conversation would be, whether the order applies to the person or not. That strikes me as making sense. I just wanted to ask you from an implementation standpoint. I mean, the point of the executive order is that they're taken outside of our jurisdiction. So I'm just really questioning, to what extent, it's appropriate for us to, have the appearance of attempting to manage that executive order when it's outside of our authority.
Mr. Chair, may I address Commissioner Deering's comment?
Sure.
At this juncture, Commissioner Deering, what I am suggesting is that staff identify whether a list is available of whom this order applies to and what their circumstances are and what recusals have already been noted. I don't understand how that request could be construed as managing the executive order. We're simply asking for the information.
Well, Mr. Chairman?
Yep.
I guess the fundamental question really that is underlying all of this is, and I don't think anybody's challenging this because I haven't heard anything that any commissioner has said that in any way suggests that the executive order was somehow unauthorized. So if we're going to approach this in a logical and cogent manner, then I think the first question is, if nobody has issues about whether the executive order was legally inappropriate, and it doesn't sound like that's the case, then the question becomes the one that Monica's posed, which is, what we don't, if we don't have the jurisdiction, then I understand that some commissioners may think that it's good public policy to try to understand what the chamber is doing to ensure that there aren't, what would otherwise be impermissible conflicts created. There's no question. I don't think anybody on the commission is suggesting that, that isn't a sort of a worthy question. I guess the question is, I'm concerned that, we're setting out on yet another fool's errand where, we think that we have the ability to compel something. And, look, this happens to be the executive chamber, but, why would this be any different than if we decide we want to demand from, I don't know, legislative ethics, certain information that they keep that we're not entitled to? To me, it's not any different. And again, I don't think any of the commissioners I've heard speak are questioning, the public policy of wanting to make sure that in inviting members of the public to assist in an unprecedented, public health crisis, that attention shouldn't be paid to whether there are or are not conflicts that might be created. Nobody's suggesting that. But what I'm concerned about, Mr. Chairman, is yet again, this turns into some sort of fool's errand, and then there's going to be, I don't know, commentary and newspaper articles, and we go down yet another rabbit hole. And I would also add that, we are at a time where, our staff is stretched thin. And I know we're going to go into executive session and we're going to talk about ongoing investigations where, we have staffing issues where because of where we are generally and because of the crisis. And so yet again, Mr. Chairman, I'm concerned about deploying staff resources on a fool's errand that at the end of the day, we don't have the ability to do anything about it. If the commissioner wants to find out what the chamber's doing, let them contact the chamber. If the commission consensus is that we ask the chamber what they're doing to make sure that there aren't conflicts, notwithstanding the executive order, if that's what people want, that's fine. But if the chamber, and there are plenty of good public policy reasons why they wouldn't want that information publicly disseminated. Perhaps it could be disseminated to us, in a more confidential way. But if they determine that it's not in the public interest to make this disclosure at this time, then boy, I really don't think that we're going to, it's not going to be useful. It's not going to be useful for anybody if we then set ourselves up into something that we can't deal with and we can't control. So that's my view on it, Mr. Chairman.
Thank you.
May I respond, Mr. Chairman?
Yes, go ahead.
What I am suggesting is informational only. But I start with a immutable fact. The executive order has completely supplanted our function. And I believe institutionally it is our responsibility to ask the question, what are they doing? How is this order being applied and to whom? And it's information. Now, they make the decision that they don't want to disclose the information, then that's a next stage discussion, not for today.
Well, Mr.
What
Chairman,
I am proposing is the staff make a phone call and ask, is this information available? And if so, turn it over to us.
Again, Mr. Chairman, nobody's questioning the public policy interest in this, but I always find these discussions curious because they always inevitably focus on the executive branch, which is fine. It's certainly within our purview. I think I can count on one hand, maybe, the times that we've ever asked the legislature for similar statistical information. How many complaints have there been filed against members? What kind of discipline has there been against members? And I'm not suggesting, Mr. Chairman, that we go ahead and do that because, again, to me, the legal analysis and the public policy analysis starts with the question I framed before. If the executive order is legally appropriate, then, we can ask for whatever we want, but again, I don't want to go down the rabbit hole of, gee, if the chamber has legitimate public policy reasons for not providing every answer to what commissioners ask for, then I really think it's going to, where are we going with this? So in any event, I don't mean to belabor it, but I do think that it's worth noting that, these kinds of requests, always seem to go down the same street, which I find curious. Thank you, Mr. Chairman.
Okay. Anybody else on this? So, Monica, if you would, I'm sorry, was somebody about to say something?
Yeah, Jim Deering.
Hi.
I just want to say that I agree with the comments from Commissioner Horowitz. And I think they're consistent with what I said, but in a more articulate way.
So, Monica, why don't you just start by asking the chamber if they've got a process, and then report back to us, and we can decide if there's anything else that we want to request. Let's just take it step by step, I think.
Okay, will do.
Okay.
Thank you, Mr. Chairman.
You're quite welcome. At this point, we are now concluded with the public session, so I need a motion to enter into executive session, please.
I'll move.
Commissioner Deering.
Thank you. Second, thank you, Commissioner Fisher. Martin, can you take the roll, please?
On the motion to executive session, Commissioner Cullen,
Yes.
Commissioner Deering,
Yes.
Shapiro, please.
Yes.
Fisher, please.
Yes.
Horowitz,
Yes.
Jacob,
I vote yes.
Mr. Jacob, Mr. Levine,
The answer
Yes.
is yes. Sorry.
McNamara,
Yes.
Yes.
Weissman,
Yes.
Yates, and Chair Rosen.
Yes.
I'll come back. Commissioner Jacob
Yes.
and Judge Yates. Right.
Mr. Yates is muted.
He's unmuted now. Or, nope.
Yes.
Go ahead, Commissioner Yates.
Yes.
Thank you. All right, motion's unanimous.
Okay, stand by. Oh, I'm sorry. I stepped ahead of you, Chair.
It's okay.
Okay, so are we ready? Or let me stand by. Okay.
We commence one substantial basis investigation, and we authorize steps in several investigative matters, closed 4 matters, and discuss several other investigative matters.
Unless someone has something else, is there a motion to conclude the meeting?
I'll make that motion.
Second. All right, on the motion to adjourn, Cullen,
Yes.
Deering,
Yes.
Shapiro,
Yes.
Fisher,
Yes.
Horowitz, yes, Jacob,
Yes.
Levine,
Yes.
Partee,
Yes.
McNamara,
Yes. Yes.
Richard.
Great, that's it. Take care.
Thanks, everyone.